Ladies and gentlemen, this is still the court of public opinion, and I am still Francis Dirito Karuru. I am not a lawyer, like I have said in the past. I'm not an advocate. I am a teacher by training and trade. But above all, I am a citizen of the Republic of Kenya, a person who has the right to walk this earth like you. So far, ladies and gentlemen, citizens, I have taken you through the suspect crime, the suspects themselves, and the persons and public institutions which are supposed to take up issues that affect the citizens, such as this particular case, where a citizen feels that their their honor has been abused by fellow citizens and they, the victims, deserve redress. For crime, the common practice is for us to turn up at the police station. That is how we have always done it. And the usual practice so far has been for the police to arrest the suspect, perhaps detain them for a day or two, more so if it is on a weekend. And the average member of the public takes that to be justice, the fact that a suspect has been arrested and detained for a day or two. But no, that is not justice. Justice is when the suspect and the complainant turn up in court and the complainant tells their story and the magistrate or judge, whatever the case, listens and the suspect defends themselves and the judicial officer presiding over the case proclaims justice between the suspect crime and our courts. There is a lot of horse trading where the suspect confronted by the prospect of a fine or time to be served in jail offers various public officers inducements so that the matter does not see its day in court. Now, this is very bad because people are making money through the prostitution of justice. Of all things, the prostitution of justice, which is very wrong because the human being without established avenues for justice is being invited to a very expensive way of living where I, as an individual, I take it upon myself to extract my pound of flesh from the suspects, and that is very expensive because I am the victim. I am bitter. If you allow me to extract justice from the suspect, I could go overboard and do more harm or damage that is not proportionate to the crime. It is tempting. So here I am before Justice James Wakiaga, and James Wakiaga has listened to both sides. To me, the applicant in High Court Miscellaneous Application number 57 of 2013 at Nyeri, Justice Wakiaga has listened to a state functionary, Mr. Jue. I want to repeat that one. That on one side is I, the victim. For me, it is very personal. On the other side is a state functionary, Mr. Jue, who does not stand to lose or gain anything, who does not even live where I live. So whether he wins the case or not is not personal like me. It's not personal like me. Now, before Justice Wakiaga is an application to compel the Honorable Chief Magistrate Wilbroda Juma to sign my complaint in the manner of Section 89 of the Criminal Procedure Code. The Honorable Wilbroda Juma, for reasons best known to her, has decided not to sign my complaint. So, to start my story with a conclusion, the Honorable Justice Wakiaga dismisses my application. The Honorable Justice James Wakiaga dismisses my application on the grounds that I do not intend to prosecute the criminal case privately. Let me repeat that. The Honorable James Wakiaga says that since the applicant has submitted that he does not intend to institute private prosecution under Section 88 of the Criminal Procedure Code, I see no purpose which will be served by the Chief Magistrate signing the complaint herein. Let me repeat that. The Honorable James Wakiaga is saying that since the applicant has submitted that he does not intend to institute private prosecution under Section 88 of the CPC Criminal Procedure Code, I see no purpose which will be served by the Chief Magistrate signing the complaint herein. Now, remember, we are before Justice Wakiaga. We are not before the Chief Magistrate Wilbroda Juma. The Chief Magistrate Wilbroda Juma has not interrogated me to know whether I intend to prosecute the matter as private prosecution. No. Justice Wakiaga, like I said in the past, he did ask me what I intended to do with the complaint if he ordered the Honorable Chief Magistrate to sign the complaint. And out of modesty, I did say in court that we could place it before the Director of Public Prosecutions. That's how I put it. And we could place it before the Director of Public Prosecutions. That was quite modest in that it did not mean that the justice orders the Director of Public Prosecution to take up the complaint. No. But I was suggesting under the circumstances, under the heat of the court, that we place the complaint before the Director of Public Prosecutions for the director to decide what to do with the signed complaint. There may not be such procedure, but nothing stops us from doing that. Nothing. However, the right response, if it were not for my respect for the Honorable Justice Wakiaga, the right response should have been the Honorable Justice Wakiaga. What I'll do with the complaint is none of your business. Let me repeat that. The right answer, the explicit answer, should have been the Honorable Justice James Wakiaga. What I'll do with the signed complaint is none of your business, because the law is clear in the institution of proceedings that once the Chief Magistrate has signed the complaint, what happens after that? So, the Honorable James Wakiaga, the Court of Public Opinion now is telling you that what the complainant was to do with the signed complaint was not your business then and not your business today. So please write that somewhere in your chambers that that's not your business. But more disappointing, and this takes a leap of imagination, was that the Honorable Justice Wakiaga should have known that what was before the court was the court turning up before the Honorable Chief Magistrate Brother Juma and telling her, the Honorable Chief Magistrate Brother Juma, sign that complaint as per the law and follow the steps as in section 89 of the Criminal Procedure Code and justify the money you earn. That is how the Honorable Justice James Wakiaga should have put it. So, on the day that the Honorable Justice James Wakiaga is sitting to write his judgment, he should have known that a suspect criminal incident and some suspects were walking this nation free because the Honorable Chief Magistrate did not sign the complaint as required by the law. And his hand should not have been guided by what the quip, I call it a quip. His heart should not have been guided by the quip that the complainant, the applicant, made in court. No. His heart should have been guided by the bare circumstances of the complaint before the Honorable Brother Juma. I have said in the past that technically, to date, Swiss Fitia, that a complaint is before the Honorable Chief Magistrate, Brother Juma, and a criminal case is instituted already. A criminal case is instituted already by virtue of the fact that I made a complaint in writing. So a case is there. It is not numbered, does not have a file, but it is there. So the whole institution of the judiciary, represented by one of their own, the honorable, and I usually keep asking, we still have to call some of these people honorable, and the honorable Chief Magistrate Dajuma, for reasons known to her, she has failed to sign that complaint. So the matter is in limbo to that extent, and suspects are walking free. Ladies and gentlemen, Kenya is a blessed country. It's a very blessed country. We are surrounded by countries that went to grief at one time or another. We have Somalia, brothers in Somalia, nice people, very old nation to say that, as I do in gesture to uh, people on Twitter. It's a very old nation. And at one time, they imploded, went bust. We have Ethiopia, another very old nation, which has gone to grief in the past. We have Uganda, which has gone through the same. We have Rwanda, which has painfully gone through the same. We have Congo, big, wet, very fertile, but a sick man. We have the Central African Republic, same thing. We can name countries. Actually, as a matter of fact, you could say Kenya is the exception. Do you need to mention Sudan, perhaps? No, let's not mention Sudan because those are too many. Now, for us, Kenya, why is Kenya blessed? Kenya, we are blessed basically because we used to be led by people who believed in something, particularly the public servants. They believed in something. We are blessed generally because in small places, particularly in schools, we have children, and these children on Mondays and Fridays, they start at attention and they sing the words of our national anthem. Now, our national anthem is a very considered prayer. In this anthem, we tell God, O God of all creation. So we have accepted that He's the God of creation, the Creator. O God of all creation, bless this our land and nation. Bless this our land and nation. And then we make a commitment to our Creator that justice is going to be our shield. Justice is going to be our shield. And that is where now we are taking oath before our Creator that God Almighty, our Creator, if you bless this our nation, if you bless this our land, a nation, then justice is going to be our shield. But do we meet our end of the bargain? No, we don't. We don't. The children are still mumbling those words. They don't even understand what is justice. But we, the people who understand what is justice, people like Justice James Wakiaga, all the Honorable Chief Magistrate Wilbroda Juma, they take our oath before God, uttered by the innocent, and they answer a call of nature all over the oath. So I hope I don't sound like a prophet of doom, but actually, Kenya has been living on borrowed time. Because ideally, we are ripe for punishment. We are ripe for punishment because when we fail to punish the perpetrators of great injustice on the public, then the Almighty, our Creator, does not want to be counted with that. And it is not sustainable that we don't punish, then it's just a matter of time before this erstwhile blessed country goes to the dogs. Soon, sometime soon, this should happen because we have defiled an institution whose business is to proclaim justice. Justice Wakiaga does not dismiss the High Court miscellaneous application number 57 of 2013 at Nyeri because it does not conform with the law. Justice Wakiaga does not dismiss the High Court miscellaneous application number 57 of 2013 at Nyeri because it does not conform with Section 88 of the Criminal Procedure Code. Justice Wakiaga does not dismiss the miscellaneous application number 57 of 2013 at Nyeri because it does not conform with Section 89 of the Criminal Procedure Code. He dismisses the case because, as he puts it, the applicant does not intend to conduct private prosecutions, or rather, the applicant does not know what to do with the complaint once signed by the Chief Magistrate. Ladies and gentlemen, let me put it like this. First, under Section 89 of the Criminal Procedure Code, there is no public or private institution of proceedings. Let me repeat that. Under Section 89 of the Criminal Procedure Code, there is no public or private institution of proceedings. There isn't. There is just institution of proceedings. Full stop. The law is clear. It's not public and it is not private. Similarly, under Section 88, there is also no reference to private prosecution or public prosecution. There is, however, a distinction between the Director of Public Prosecution and other people conducting the trial. That distinction is clear, but there is nothing in Section 88 referred to as private prosecution. Ladies and gentlemen, I had committed to address Justice Wakiaga's ruling, and that's what I want to do today in this video. I had given this video a cultural twist by calling it pieri. My having schooled in a different Kenya where you pick some few phrases from the different subnations that we have in Kenya. I'm told the Honorable Justice James Wakiaga is low, and if I use the word pieri, he will take it as some figure of speech. And the pieri bit is it's about his work, not about him. No, I know he could be a parent, be even a church elder. But like we said in the beginning, I start by my hard work and he starts by his hard work. And I even recommend that you, the public, get to the habit of studying by your hard work. Start by your third. I start by my third. So if in the course of public service, or even in my personal life, I make third, then let me start by it. If in the course of public service, Justice Wakiaga makes third, let him start by that. Says, very good. Now, Justice Wakiaga, he numbers his points, which is a very good approach. He doesn't use prose. Prose is good, but maybe it's a bit passe. It's a bit passe. Because here there are points that we can call attention to. So in his number 2, he says, the application was supported by the affidavit of the applicant, wherein he deponed he had drawn and filed an application to compel the Chief Magistrate to sign his written complaint as per the procedure outlined in Section 89, 1, 2, and 3 of the Criminal Procedure Code. That is very nice. It's a nice opening statement. What he does not mention is that the applicant has a bouquet of documents before him. It is important. He should have mentioned that the affidavit is supporting his case with documents that are before the Chief Magistrate, which include a report on the crime as a complaint, copies of letters to the OCS of Nyeri Police Station, copies of letters to the Office of the Director of Public Prosecutions, and attached are the receipts, the forwarding receipts for those documents. And it would be nice if Justice Wakiaga could have captured that bit, that before him were documents that were providing evidence that the applicant did not rush to court. He took time. He gave public institutions time to do what they exist for, but they did not. So he failed that bit. I'll be highlighting some other failures on Justice Wakiaga's part. So This is a grave failure, very grave to me. So I'll be showing him in a short while.